Without further ado, therefore, I'd like to hand the baton to Andrew. Andrew Sangster's been a regular contributor on our Hospitality Insights call, so particularly grateful, Andrew, to you for coming back once again. Again, Andrew's known to many of us, but he's managing director and editor of Hotel Analyst, which is one of the hospitality industry's leading sources of insight, analysis, and market intelligence. And he is well recognized as one of the sector's most informed commentators. He spent more than 2 decades analyzing the global hotel market, so there isn't much he doesn't know about the hotel landscape. So, Andrew, without further ado, let me hand you the baton, and I think you've got sharing permission, so you can crack on.
Right, let's just get on with that. There we go. How's that looking?
All good.
All good.
You
Super.
just need to put it onto slideshow,
Yeah,
but other
there
than
we
that, we're all
go.
good.
We are have lift off. Great. Well, thank you for that.
Bingo.
That was a great segue, I think, into what I'm going to talk about. Really, I'm going to be talking about the mountain we have to climb. As a bit of context, UK tourism underperforms its competitors. It was mentioned there in terms of European context, but if you look at a comparable economy like Germany, Germany has a higher GDP contribution from tourism and it's a higher share of employment. And you wouldn't say the German climate is any better than ours. So there's no specific reason for that other than that we need to shape up, I think, in terms of our tourism sector. Now, what I'm going to talk about is specifically the Employment Rights Act and not as a piece of employment law, but as a piece of economic policy, what it actually does, who it actually hits, and why the government is doing it anyway. And the short version is this. The official cost estimate from the government is that it's going to be £1 billion impact across all sectors. The real cost is probably going to be 10 to 20 times that. And I'm going to argue that hospitality is not collateral damage, it is the target. To understand why, you need to look beyond the legislation itself and into the economic thinking that produced it. So I'm going to go through 3 parts: the economics, what the Act does, what the government says it costs, what it actually costs, and why hospitality carries a disproportionate share of the burden. The second thing is the politics, the intellectual framework behind Labour's labour market reforms, and in particular, the influence of the Resolution Foundation. Third, I'm going to finish with what it means, the structural outcomes the legislation will force. At its core, the Employment Rights Act attacks what policymakers call one-sided flexibility. The argument is that employers, particularly in sectors like hospitality, have built operating models on the ability to flex labour up and down at will, and that workers bear the cost of that flexibility in the form of unpredictable income and weak protections. The legislation addresses this through 4 pillars: greater rights to predictable working hours, stronger protections around shift scheduling, an expanded employer duty to prevent harassment, including from third parties. And I think this is a much missed issue here. And broader protections in employment disputes, including unfair dismissal from day one. Individually, each of these looks like a technical adjustment. Collectively, they represent a fundamental rebalancing of who bears the risk of demand volatility. And in hospitality, demand volatility is not a peripheral concern, it is the defining feature of the business. Now, the cost. When the bill was first introduced, the government's own impact assessment suggested costs in the range of 1 billion to 5 billion per year. The 5 billion figure became the headline. Business groups quoted it repeatedly. It was already a large number. Then in 2026, beginning of this year, the government published a revised estimate. The new figure, approximately 1 billion. That's about 0.1% of the total UK employment bill. In other words, the official cost fell by around 80%. That's a remarkable revision, and we need to look a little carefully at that. This slide sets the 2 estimates side by side, and the gap between the government's assessment and economic reality is striking. The reduction reflects 3 things. Some provisions were softened or delayed during the parliamentary passage. The revised analysis uses a much narrower definition of cost, focusing almost exclusively on direct admin and compliance burdens, and the modelling assumes relatively smooth adaptation. that businesses will simply absorb the changes without significant operational disruption. What the estimate largely excludes are behavioural responses, the restructuring, the hiring decisions not taken, the shifts not offered, the businesses that close or consolidate, and that is where the real costs lie. This is the mechanism that matters. Hospitality businesses manage demand volatility through a flexible staffing buffer, a layer of variable hours workers who can be deployed when demand is high and stood down when it falls. That buffer is what allows a restaurant to staff a busy Friday and a quiet Monday without carrying fixed labour costs it cannot recover. The Employment Rights Act systematically removes that buffer. Predictable hours rights mean employers can no longer vary shifts at short notice. Scheduling protection restricts last-minute roster changes. Day one unfair dismissal rights raise the cost of adjusting headcount. Taken together, these provisions convert what was variable labour into something much closer to fixed labour. The official cost estimate of 1 billion captures the admin overhead of compliance, the paperwork, the systems, the training. It does not capture the economic cost of losing the buffer itself. That cost, the real cost, is in the range of 10 billion to 20 billion per year across the economy. It comes from defensive compliance, operational restructuring, increased legal exposure, and fundamental business model adjustment. The largest component by a considerable margin is the loss of flexibility. That is not an admin cost. It is an existential one for business models built on variable deployment. The flexible buffer argument applies across the economy, but hospitality is uniquely exposed, and the data makes this case starkly. Resolution Foundation research, the Resolution Foundation is the government's favourite think tank, and it's the one the government looks at for its own evidence. The Resolution Foundation shows that 41% of hospitality workers are on variable hours contracts. Across the wider economy, that figure is roughly 13%. Hospitality's dependence on flexible labour is 3 times the national average. In absolute terms, that translates to around 640,000 workers on flexible contracts in hospitality. These are not peripheral roles, they are the core operational workforce. The staff who cover peak service, seasonal surges, event-driven demand. Remove the ability to deploy them flexibly, and you do not trim a margin, you break the operating model. No other major sector combines this level of variable hours dependency with the demand volatility that hospitality faces. Retail has flexible contracts, but more predictable footfall. Construction has variable demand, but different contract structures. Hospitality sits at the intersection of maximum flexibility dependence and maximum demand uncertainty. That is why this legislation hits the sector harder than any other. And this is a second dimension of risk that is easily underestimated. The Act strengthens the employer's duty to prevent harassment, including, and this is critical, harassment by third parties, customers, guests, clients. In a sector defined by face-to-face interaction, that creates a compliance chain with no clean endpoint. Hotels and restaurants cannot control what a customer says to a member of staff, but they can be held liable if they are judged not to have taken all reasonable steps to prevent it. And that's the woolly wording the legislation has. The phrase all reasonable steps is where the legal exposure sits. It means training, monitoring, documentation, incident reporting, and a paper trail sufficient to satisfy a tribunal. It is useful to set this legislation alongside the other major employment cost increase of recent years, the employer NICs rise in the 24 budget. That NIC increase raised the employer rate to 15%, with projected revenues of 24 billion to 27 billion a year. That's obviously a far larger headline than the official estimate, but the nature of the two policies is fundamentally different. NICs are a tax. They raise the per head cost of employment by a fixed predictable percentage. Businesses can model the impact, absorb it, or pass it through. The Employment Rights Act is a structural intervention. It changes the rules of how labour is organised, deployed and managed. It does not simply make workers more expensive, it makes certain ways of using workers illegal. For hospitality, a sector built on variable deployment, that really, really matters. Right, so let's get into the, why is the government doing this? And this goes to that think tank I talked about, the Resolution Foundation. Um, the Resolution Foundation has been the single most influential think tank in shaping Labour's labour market policy. Its analysis of the UK economy rests on a specific diagnosis that Britain suffers from three interconnected structural problems: low pay, insecure work week productivity. In this framework, the three are not independent. Low pay and insecure contracts suppress productivity by reducing worker investment, weakening training incentives, and enabling low value business models to survive. Hospitality, in this worldview, and it is the worldview of the Resolution Foundation, not my worldview, hospitality is Exhibit A. The three UK problems: sectors with high rates of variable hours contracts, low median wages, and high turnover are not simply flexible, they are structurally underperforming. Again, this is Resolution Foundation worldview. The flexibility is a symptom of weak management, thin margins, and chronic underinvestment in workforce development. Across multiple reports, the Foundation has characterised hospitality as a sector marked by low wages, high turnover, heavy reliance on variable hours, and, in parts, poor compliance with basic employment rights. And I think this is going to bring us to the most revealing piece of evidence about the government's thinking. The Resolution Foundation's New Year Outlook report contains this phrase that we've got encouraging signs of a mild zombie apocalypse. What this means: it means the Foundation welcomes the exit of weak, low productivity firms from the economy. It views a period of elevated business closures not as a policy failure, but as a structural correction. The economy shedding business models that should not have survived in the first place. The argument is that cheap, insecure labour acts as a subsidy to inefficiency. Remove that subsidy through regulation, and you force either adaptation or exit. This is not a side effect of the Employment Rights Act. It is the intention. And that's the intellectual core of the policy. The Resolution Foundation, and by extension the government, is using labour market regulation as an instrument of industrial policy. The mechanism is straightforward: raise the floor on employment standards, and businesses that cannot operate above that floor either restructure or disappear. In economic theory, this is enforced creative destruction, what the economist Joseph Schumpeter outlined and coined the term. For sectors characterized by low wages, high flexibility, and thin margins, and hospitality ticks all of those boxes, the implication is deliberate and direct. The government is not unaware that this legislation will cause business failures in hospitality. It has decided that some of those failures are desirable. So where does this leave hospitality businesses? The Employment Rights Act functions as a macroeconomic filter. It raises the minimum viable threshold for operating a labour-intensive business in the UK. Businesses above that threshold will absorb the costs: higher compliance, tighter scheduling, more structured employment. They will be less flexible, more expensive to run, but they will survive. Businesses below that threshold face a binary choice: restructure fundamentally or exit. There is no scenario in which the sector emerges from this legislation unchanged. The only question is the speed and the severity of the adjustment. There's going to be four structural outcomes, I'd suggest. First is consolidation. Larger operators absorb smaller ones. Scale becomes a compliance advantage as well as an economic one. The independent sector shrinks. Second, automation, where labour flexibility is restricted, technology substitutes self-service check-in, automated ordering, dynamic scheduling software, anything that reduces headcount dependency. Thirdly, pricing restructures. Costs that cannot be absorbed get passed to customers. Average room rates, cover charges, and service fees rise. The consumer pays for the regulation. Good luck with that one in the current environment. And fourthly, fewer marginal jobs. The entry-level variable hours positions that have traditionally been hospitality's route into the labour market become harder to justify commercially. The people the legislation is designed to protect may find fewer opportunities available to them. And that's the paradox at the heart of this policy. So, to conclude, the official cost of the Employment Rights Act has been revised down to 1 billion. That number is a work of careful scope limitation. The realistic cost, accounting for behavioural responses, operational restructuring, and loss flexibility, is 10 to 20 times higher. Hospitality is disproportionately exposed, not by accident, but by design. The sector represents precisely the kind of labour market model that policymakers have decided should not persist. The question for businesses on this call is not whether to comply, it is how to adapt to a policy environment that views hospitality's current operating model as part of the problem it is trying to solve. Happy days.
Wow. Um, yeah, that's an interesting picture. It doesn't bode well for any of us. Thank you very much for that, Andrew. As you say, it's fairly stark contrast to the relatively upbeat presentations from Kat and Mark about how they're working to drive demand and improve the environment for the sector. But it's a pretty scary picture.
Yeah, and the
Um,
fact is we're already lagging rival economies like Germany. We're already behind. This is going to make it significantly worse and significantly harder. And I don't think people have really factored in just what an apocalypse this is going to be for our sector. I think this is far worse actually than the employer NICs increase, which has seen hundreds of thousands of jobs disappear from the sector already. So this is going to be brutal.
and when does the legislation actually kick in, Andrew?
It's framework legislation, so it's coming in over a period of time. So the full impact of it's going to be in sort of 27, so next year. The other thing is the actual impact of it is also going to take its time. So that piece about the third party harassment is worth noting, for example. So what you see historically when we've had similar bits of legislation, it takes 2 to 3 years before people catch on that this is a great, you have this serial litigant in the spot. So this is an easy way to earn a few grand. And this is what we're going to see happen as it comes into force. So from a hospitality operator's perspective, say you've got a conference and banqueting business, you employ an outside agency, you as the business are liable for that agency staff. So if you've got one of those staff members, they will sue you, not just the agency. So you've got this, and frankly, what is with these tribunals, it's a coin toss as you go into them. Most people are going to say, well, 3, 4 grand, go away, please. But people will learn that, and then they'll just go from job to job to job and get doing it. And we've seen this happen in the past, and this is what we're going to see with this. This is an absolute nightmare, and it's about to transpire.
Mark, any views on that?
Yeah, no, it's certainly something that's been muted by a number of our colleagues. That obviously we've gone through the Fair Work in Hospitality inquiry up here as well, which the publication of that came out it was last year, and there's some recommendations that have sat within there for the ministers. But things around island variables and all this, how do you contract, and will you contract? There are a number of alarm bells in there, and Andrew, as Andrew's highlighted, so it's not going to be easy. And when you're trying to attract people in to come and work in the sector, and accelerate it and push it for all the right reasons, so it's a lot to grapple with. But as we know right now, the businesses are trying to navigate their way through all sorts of other immediate challenges, just in terms of staying afloat. And what's so sad is that we know there's a real ambition with so many of the operators out there to do what they love doing. But if this becomes a blockage for them, then it's there. I guess and once you get a bit of a roller coaster, I sense there'll probably be more movement south of the border in terms of the human piece and the challenges into tribunals, etc. But Fair Work is very much front and centre in terms of the Scottish government's agenda anyway, and the hospitality inquiry, which was the first one I think behind construction, has been published. And there's been some good contribution in there from the industry bodies themselves and operators. But there is a worry. without question.
Well, I mean, an interesting personal sort of experience of mine was when I launched Holland Coast Hotels. Uh, one of our sort of key pillars was that we'd get rid of 0 hours contracts because we thought that was the right thing to do. And in fact, I think it was one of the covenants from our debt funders, the Scottish National Investment Bank, that we should eliminate 0 hours contracts. So we did this, and only to find out a lot of people actually wanted 0 hours contracts because
Yeah,
it
well, I was
worked to
going to
their
say
advantage.
I was going to say exactly that, Roddy. More and more people are telling us. I mean, I've got young ones. They would far rather have that flexibility. Many of them are doing 2 or 3 different jobs in different sectors as well. That choice. So there is a behavioural change again with some of the workforce. But there were those that do want it, and then there are those that are quite happy to operate in that sort of space with no guarantee of hours. But yeah, it's a minefield and it is a concern. And obviously it is a cost, but it again, it's this repositioning of the value of the sector and not seeing it as a demon. And
Yeah.
I think this is a driver of so much economic prosperity into communities as well, that language and the narrative has to change, and the politicians need to better understand that, because we're 245, well, we're not 245,000. I think our workforce has shrunk to about 239 now. So but you've got still the largest employer across the country, and really it affects and impacts every household when tourism doesn't work. As well, as we all saw with COVID, you would have thought some of the shift of the dial might have happened in terms of being more supportive policy rather than anti-growth policy.
Well, thank you all very much. I'm conscious of time. I did warn everybody we were likely to run over a little bit today, but I think it was worth it because I think the input from all three of you, Andrew, Kat, and Mark, has been invaluable and very positive on one hand, in that the demand is there and it's growing, and the good work of Visit Scotland and in that regard is there for all to see. So keep up the great work, Kat, and your colleagues at Visit Scotland, and Mark's work in terms of lobbying Holyrood and the Scottish government is obviously having a positive impact as well. But underlying that, the Employment Rights Act is clearly there to create significant headaches for all operators in the sector over the years ahead. So a bit of a curate's egg, I guess. But